Well, hi everyone, Sean Humphries here. Welcome to All Things Retirement. Well, in this video, we are going to have an interview with Krista Clendenning, who's a lawyer with Tradition Law. And the specific topic is, what are the trigger points that would cause you to take a look at your will to confirm whether it needs to be updated, changed, even redone? And so Chris is going to talk about some very practical trigger points often we're not aware of and sometimes surprised by. So it's a really helpful video. Estate planning, powers of attorney, healthcare directives, they're all really important components to your overall retirement income plan. So this is an area that you should take a look at from time to time and make sure it's updated. If you watch the video and you want to connect with Krista, there's contact information in the show notes so that you can get a hold of her. And again, if you're looking at the video and it prompts you to want to take a look at your retirement plan, there's contact information links in the show notes to get to us as well. Anyway, I hope you enjoy the content. You take care. So it's great to have a chance to talk about all things estate planning again today with Krista. So hi, Krista, how are you doing?
Hello, great. Thanks for having me.
Oh, it's a pleasure. So in today's topic, we thought we'd cover off what are the trigger points for, updating your will, your estate planning. And when I sit down with clients often, I say there's two major trigger points, but these are not very exhaustive and they're pretty broad. So I often say, well, if it's been 5 years since the last time you reviewed your will, probably a good idea to dust it off if you know where it is and take a look at it. Or if there have been changes to your family or financial circumstances that would warrant a review. But that's a pretty broad template for triggering a review. And I know that you've got some more defined trigger points I think would be helpful for people to hear, because it may prompt them to want to sit down with their lawyer or seek out advice on their estate plan and having it updated. So maybe you could share with us some of those trigger points you typically see in your practice.
For sure. So yeah, one of the things I tell clients is that, even though we do the estate plan, we finish it up, it's an evolving thing. So you have to go back to it, look at it, and you really want to see if there's any changes in your circumstances, changes in your assets, your world, your plan, your goals, your family structure. Those are all going to generally be triggering points to review things and make sure everything's still up to snuff. So assets is a big one. So any big change in your world, if you are restructuring your investments, there's big shifts between registered or non-registered. If you set up a corporation or you change a share structure of a corporation that you have, looking carefully at that. I think lots of the times people get assets held in a corporation mixed up with personally held assets, and they may be thinking they're giving a property through their will, which is actually corporate owned, and you have to only give shares in corporations, and the corporate property follows the shares. So that's one hang up that sometimes people have.
Okay.
Real estate. So the more property you own, the more complicated things get, more tax planning you might want to be doing. If there's also a specific plan about, say, a cottage going to certain family members or a house going to a certain family member, making sure that plans are up to date in the will in that respect as well.
Can I just ask you a question on the real estate piece? Because I think we've maybe talked about this before, but if all my real estate is in, let's say, the province of Manitoba, my assumption is that your basic estate plan, your will plan could cover that. But when you have, let's say they have a winter property or a place in Arizona or Florida, or they've bought some property in BC. I think you've mentioned that sometimes there's a requirement to have a separate document or even a will property plan on those things. Is that correct?
Yeah, it's definitely worthwhile taking a look at it, because there can be different strategies to make the administration of that estate faster or easier. One of the strategies is doing a multiple will. So maybe having a will for your primary stuff in Manitoba, your primary residence here, and possibly a second will that you've done maybe with a BC lawyer that meets their requirements. So you can deal with the BC property simultaneously in that jurisdiction. People without the multiple will, they end up taking their one will from Manitoba, now trying to reprobate in the other jurisdiction. And it gets even more complicated if you're going into another country like the States to try to deal with things. So taking a look at those things ahead of time and seeing if there is a way to simplify or something is a good idea for sure.
Okay, perfect. And so real estate's one. What are some others that you listed there?
So corporations, big changes in wealth. So how you're structuring investments. I think sometimes people lose track of the fact they might have made beneficiary designations on
Right. Yeah.
registered investments, and that always comes into play too. So as another kind of sit down thing to do, if people feel comfortable kind of doing it, is looking at your assets and looking at what would happen with them on death. And the estate doesn't necessarily cover everything. The will only covers what you're going to personally own, what falls into your estate on death. If you have joint property, that's going to go to the joint owner. It doesn't actually fall into the estate. And same thing goes with beneficiary designations. So if you have an RSP or a tax-free savings account or life insurance, if those have a beneficiary designation, those funds are going to flow to that individual and not into the estate. So I think doing a review and looking at that and what will happen, where does the money go? Is there enough to cover the taxes that are going to hit the estate on death? Is a good review to do.
Yeah, no, exactly. And so I think that point's really an important one, is that people forget what the will plan says. They will go into their financial institution, they maybe do some registration changes, like you said, whether it's a single registration or joint registration, or change beneficiary designations on registered accounts. So there should be an automatic, light that goes on that says, okay, I need to understand how this intersects with my will plan and my estate plan. So that's a good point.
Yeah. And even with joint ownership, I mean, people have different intentions behind joint ownership, and you may be putting a child onto an account just to facilitate access. For some reason, maybe you're not using a power of attorney and you're thinking that that's a good strategy there. So there's things you should probably do to document that, so it's clear that that joint account isn't meant to go to that child. It's still meant to be part of the estate on death, or maybe it is meant to go to that child, and we just want to make sure that's really clear so we don't have any conflict on those issues when the person eventually passes away.
Yeah, exactly. Well, perfect. Good
Yeah.
advice. Any other points there?
I think I could talk about relationships next. That's another
Yeah.
big one, big changes in
Yeah.
relationships. Yeah. So separation, divorce, marriage, moving in with someone, all of those are triggering events to take a look at your estate plan.
Yeah, exactly. And so it's one of those things where, people go through these life events and relationship changes, and it's not an automatic default necessarily to, take a look at the ripple effect in terms of some of those documents. Can you give some examples? So when you think of maybe to kind of motivate people as to why they should do this, what are some examples of things that could go sideways on the different changes that you talk about? So, a common one, unfortunately, people go through separation and divorce, and then they have a new partner, but maybe they don't get married, they're living common law, they see these very different kinds of relationships. What are some negative ripples if you don't attend to this? What could happen? Have you seen things in your practice that kind of went sideways for people before they had a chance to talk to you?
Yeah. So separation, there's kind of a difference between if you're separated or you're divorced. So
Okay, good point. So that's a good distinction. Yeah.
yeah. So separation, there's nothing legal that's happened to change your documents. So if you have an existing will that leaves everything to your spouse, you've named your spouse as the beneficiary of all these investments or insurance, they're going to stay on as that beneficiary until you make a change, or until you're divorced, then your will would be impacted, but beneficiary designations remain the same until you change them.
Wow. And so you can be you can be separated. You're now, with another individual in a relationship. So there's this notion of common law. So now you're living common law, and that has a certain impact financially, right? But then you have these estate documents that were drafted. And if you never went through a formal divorce, I guess, you can actually have these pre-existing arrangements that don't change. Am I understanding you correctly? And
Yeah.
maybe you can unpack the difference between when you're talking about common law marriage, how that intersects with this. So it sounds like there's some real gaps there in terms of some of the estate planning piece, even if you're technically common law.
Yeah. And common law. So the issue with common law stuff is that definition of when you hit common law varies from jurisdiction to jurisdiction. It varies depending on which law you're looking at. So family property rights, if you break up with your common law partner, I think generally it's a 3-year period, or it's less if you have a child together. For tax purposes, your common law after 1 year. So it depends on what you're talking about, which
Wow.
which why people are always confused. They think they're common law or not because they've heard
Yeah.
one definition. They don't know if it applies to them.
Yeah.
Yeah, so that makes things very complicated for common law partners to kind of sort through. But in terms of estates, so if you have a will in place, you're not divorced, you're still working through, I suppose, your divorce or your separation, and you have a new partner. So the will is going to override until you make a change or until you get divorced. A divorce would have the impact of treating the divorced spouse as deceased. So if your divorced spouse is named as executor, they can't act. If your divorced spouse is left something in that will, they won't receive it. It'll treat them as if deceased, and the property will go on to the next person named in the will.
Okay.
But the next thing you can have is a layering on of family property rights. So the new common law partner could have rights against the estate now running since they've started to live together. So it just creates a tangled web. You've got to sit down and get some advice on it to make sure you iron these things out as soon as you can.
So note to self, if you've gone through a separation or even a divorce, you got to make sure you attend to those documents that are kind of lingering in the background, collecting dust, and on the shelf, you're not thinking about them.
Yeah, exactly.
Okay. So again, what about change relationships as it relates to the death of a partner, death of a spouse? Those obviously would trigger a review of a will. Are there some specific kinds of questions that you would get into with your clients on that transition?
Yeah, so I think on the death of a spouse, take a look at things. Typically, when I'm doing estate planning, I often do planning for couples, and we will do what's called mirror wills. So the wills will leave everything to the surviving spouse, and then when the second to die passes away, there's an agreed upon distribution set out in both of their wills.
Okay.
So you don't necessarily need an update if you have it structured that way.
Yeah.
But if there's any change in things since your spouse has passed away, or a change in your other relationships or the people who you want to be your beneficiaries, you're always free to make changes to that will unless you've done something to contract yourself with your spouse about keeping things a certain way. But so depending on the type of will you've got in place, and if you've done that kind of mirror will thing or not, you may need to do a full update to your will.
Now, when you talk about relationship changes, is that in that category is also the category where, let's say I've named my eldest daughter the executor of my estate, and she's living in, let's say, Toronto, and gets transferred to San Francisco, and she's now residing in the United States. Does that kind of change trigger any review or implications for the estate planning?
Yeah. So anytime you have an executor or an attorney named in a power of attorney, or if you have trust set up in your will and you've named a trustee, if those people that you've named become US resident, they move to the States, you've got an issue there. So to simplify things, generally, you just don't want to have a US person named in those roles. One of the big reasons is tax related. So if you have a sole US executor managing your estate, the tax jurisdiction is now US rather than here in Canada for the purposes of your estate. And you're creating a bit of a accounting nightmare on both the Canadian and American side, having that person, that US resident person, operating things.
Okay. Now, are there any other kind of relational issues or relationships that we haven't covered on that topic area?
I think another one that's very surprising to people is just marriage in general, because province to province in Canada, we still have law that says marriage revokes a will. So here in Manitoba, where I primarily practice, we have that rule. So if you have a will in place and then you get married, your will is revoked. It's no longer in place. And I don't think a lot of people know about that.
Really? And so the implication, if you don't get a new will drafted, you would die intestate?
Exactly. Yeah. So if you've got a new relationship, second partner, you get married, you're thinking you've got a will in place that maybe leaves everything to your kids. It's been revoked on that marriage, and now you're stuck with the Intestate Succession Act, which here in Manitoba would generally leave 75% to the new spouse and split the remaining 25 amongst your children, which might not be consistent with your wishes.
Yeah, exactly. That's a real surprise. That's a big one, right? So you can see that getting missed by lots of people, I'm sure.
Definitely, yeah.
Any other relational changes that impact the estate planning?
I think next I talk about kids and your any
Okay, yeah,
relationship changes kind of going on to
sure.
the next generation.
Yeah, okay. So what are the implications there?
Yeah. So, I mean, another thing on review year to year, you might have something changing with either the responsibility of your kids managing money,
Sure.
or maybe it could be a capacity issue, health, a disability, or something like that. So, if there's ever a reason that your child can't accept their inheritance and manage it entirely by themselves, that's another reason to look at an update to your will. Maybe you want to look at trust options, either because you're trying to protect other income sources. Maybe they're on disability support and you want to make sure they'll continue to get that support and receive an inheritance from you. Or it might be like a functional thing. Maybe that person just isn't good with money, so we want to have someone else involved with managing the money so that inheritance lasts and maybe makes its way to the grandchildren eventually one day. So different kind of strategies there too.
Okay. That's an interesting one. One of the ones issues that's come up for us in our practice is where, the families that, they've built up fairly significant wealth. They've got kids and marriages. And sometimes you run into situations where, privately mom and dad say, we're not sure whether this relationship is going to make the turn, or, that it's kind of rocky, or, the kids are running a business and we're concerned that if the business, goes belly under and eventually that son or daughter is a beneficiary to the estate, the creditors might have access to those assets. So I think one of the things that can happen in that review process is that question as well. How good are the relationships? Do we want to make sure that the family wealth we've accumulated, when it goes to our kids, maybe it shouldn't go directly to the kids because of marriage issues or business concerns, but like you said, maybe it's best to go through the estate and to a trust, testamentary trust. Do you see those kinds of plans done? And here's the follow-up question. How many people do it in advance of any of those issues happening? And do you ever see situations where clients come in and say, you know what, we're reviewing the will plan and we have these concerns. What should we do? And you maybe talk about some of this stuff with them. Any comments on that?
Yeah, so definitely this testamentary trust strategy is one that comes into play a lot when we're looking at potential creditor issues for that child, or possibility of relationship breakdown, or maybe that spouse is a bit of a big spender and we're worried about, if the child has direct access to the money, the spouse might get more access to it and spend the money away. So all those things, having that mechanism of control where maybe it's still your child co-managing the money as a co-trustee with a sibling or someone else, that can be an effective way to kind of house the money separately and make sure it's being managed in the way that you envision by setting up a trust with certain terms consistent with that vision. But definitely it is a strategy we see, and sometimes it is before those concerns have arisen. Sometimes it's when just one of maybe 3 kids there's some concerns with, but the parents want everything to look like they're treating all the children the same. So they set up these testamentary trusts for all 3 kids, and there can be there's usually ways out to dismantle them if that makes the most sense. But
Okay, so they're not necessarily permanent structures; they can be changed.
I generally recommend we don't want them to be permanent structures, so that there's flexibility there.
Sure.
Just with ever-changing circumstances, that's usually the best way to go.
Yeah. Okay, perfect.
Yeah.
So we covered a lot of different relationships and kind of relational changes. Have we covered off the main ones that were on your list for the discussion today?
Yeah, I think that pretty well covers it. Yeah.
Are there any other categories that would prompt somebody to take a look at the will? We've covered most of them, or are there any ones that come to mind for you?
I think another one would be you yourself. So if there's anything going on with you, your capacity, a diagnosis, let's say of Alzheimer's or something, if there's a reason to think that you might have a change in your ability to execute a will in the future, it's a good idea to sit down and do a review and make sure everything is up to par where you want it, that the instructions are leaving behind, everything's good there. Because if something happens to you and you can no longer understand the consequences and the effect of doing a will or doing any of these estate planning documents, then you're not going to be able to sign that document anymore, and you're stuck with whatever plan was in place before.
That's a really good point. You know, that I'm reading, there's an author that I've been reading. He's an actuary, but he's written a series of books on different aspects of retirement planning. And he made a comment that I thought was really, really good. And we don't focus on this enough, I think, sometimes is, there's financial complexity in all of our lives. And as we get older, that complexity, not always, but can tend to increase. But there's this inflection point where, as financial complexity is increasing, our capacity to deal with that complexity can decrease, and we have to be very clear-minded about our capacity to deal with more complex financial issues or estate planning. And the more you can do to simplify, to create a plan, maybe a flexible plan, but also to bring family and trusted advisors into the situation, the more it's going to reduce the chaos or concern or lack of clarity that could happen as someone gradually sort of throws into that, whether it's dementia or Alzheimer's or just a lack of capacity to make those decisions. And he said that often people leave it too late. So by the time they're getting serious or should be getting serious about this kind of planning and other aspects of their finances, they don't have the bandwidth cognitively to really deal with the issues in a satisfactory way. And I'm not sure whether you've seen that in your practice, where not for your existing clients properly, where you've been caught in situations where the kids say we need to get mom and dad's estate plan updated or whatever, and then you're caught in a situation where they may have left it a little bit too late because of the cognitive declines.
Yeah, unfortunately, we do see that too. So when people don't get to sorting this stuff out while they have the chance or while they have the capacity to do so, it might turn over to the attorneys that are named under a power of attorney, or if they haven't done that document, you're dealing with a court application just to get control over assets and sort through things. And you're much more limited in what you can do in terms of the planning. I mean, if you're taking over the affairs of a parent, you can't make transfers to siblings or gifts or things like that. You've got to do everything in the best interest of that person. And you might lose out on different planning strategies you would have had. And then on the administration side, like when the person passes away, I know we end up with lots of those files where it's just trying to sort through a mess that's a few years deep, and maybe there's some corporations and statements weren't up to date and taxes weren't up to date, and someone's cleaning up the mess, and it's usually much more expensive and much more time consuming and much more painful just to go through it afterwards. So
yeah, exactly. Well, we've talked about this before in previous discussions where we talked about one of your partners, John, who said it would be nice if there was, we're all like butterball turkeys, and as soon as the turkey was done, a little thing would pop out and say it's done.
yeah.
And the problem with dealing with family and having these, and they can be difficult discussions. Like, I think the dynamics of families sometimes make it difficult to kind of hit head on important conversations just because of family dynamics, and all families have them. And so it creates a situation where the conversations, everyone kind of knows in the room that there are certain conversations that need to happen, but no one wants to be the first person to kind of, dive into that danger zone. And so you see situations, like you said, where unfortunately the planning and the conversations just never took place. So again, note to self for any of you, viewing the video, it's just, you always feel better. You always have this huge peace of mind. Once you sort of cover the tough topics and you get through it and do the planning, you walk out of those conversations with way less anxiety, a lot more peace of mind and confidence. It's well worth, even when there's issues and it might be tough going, to get the planning done. And I'm sure you've seen that many times in your practice.
Yeah, I think it's one of the key elements of being an estate lawyer and a wills lawyer is motivating people to get through that process and helping them through each step, because it's an overwhelming task. It's overwhelming things to think about. I mean, you're thinking about your death, you're thinking about what's going to happen when you're gone, and it's difficult to work through to start with. But I mean, what I like to do is just book that first meeting, have that first conversation, get as far as you can into the basics of what this plan needs to look like, and then give you a point form list of 5 or so things to do to a next meeting. And these are the things to talk to the kids about, and then work through the next 5 things just to break it down, because it can be overwhelming, but it's just taking those steps to get through it and getting it done now, sooner rather than later.
Yeah, exactly. So you've covered a lot of different areas that could trigger a review. Any other on your list, or do you think we've covered the main ones you typically see?
I think those cover the big ones. Yeah,
Okay.
just, I mean, anything else that's changing your goals, your wishes.
Yeah.
If
Yeah.
you inherit something, that's another time maybe if
Yeah.
a
Exactly.
cottage property gets put down to you or you and a sibling and you're trying to figure out what's happening with that next. Um, yeah, so it's just a good idea to read over that document and make sure, okay, is there something different here? Has someone passed away in this will? We've got to replace them. Or
Yeah.
are we maybe skipping because of an issue with one of the children and we're skipping that person or splitting up their share with grandchildren maybe. So there could be any kinds of changes in your wishes. Just good to review, and you might not catch them without actually looking at that plan over. And yeah.
It's like, oh, I didn't know we appointed that person as an executor.
Yeah.
I don't even know where they live now.
Yeah. You're not even friends with that person back from
Yeah.
20 years ago. Yeah.
Yeah, we're not friends anymore. So
Yeah.
yeah, so that's good. Well, this has been very helpful discussion. So it's taken it from this very high level, which the high level bullet points, changes to financial circumstances or life. That's a good start. And then you've been great at parsing out some of the more detail underneath that, the triggering events. So this has been great to have this conversation today. And so anyone watching the video, if you're looking for great estate planning help, and if you've had some trigger events that necessitate the reviewing of your will, make sure you reach out to Krista. There's contact information in the show notes for this video for that. So again, thanks so much for the time today, Krista.
Thanks so much for having me.
Well, it's my hope that you found that video helpful. So again, if you want to get estate planning advice, don't hesitate to reach out to Krista. Her contact information is contained in the show notes. And if this video prompts you to want to take a look at your overall financial wealth planning and your retirement income planning, there's a link to get to our website to start a conversation. Anyway, I'm wishing you all the best in your retirement and wealth planning journey. You take care.